3 minutes, yes, sir.
In this case, the Chancellor erred in dismissing the complaint under Rule 12 of Civil Procedure. There were 3 different claims. The first one that was raised, and the first one that I'll discuss, was adverse possession. Namely, the plaintiff, Michael Scott, sued for declaratory judgment saying that he had adversely possessed about 5 out of 20 acres of land from his stepfather. He adversely possessed it because his stepfather purported to give him the land or give him the land in exchange for some services that he provided. Mr. Scott then openly treated the land as his own for about 30 years, lived on it for about 30 years, paid taxes on it, and ultimately there was a conflict of title between the stepfather and the stepson because no actual deed was ever issued. The lower court ultimately held that Mr. Scott that he didn't adversely possess the land because he only lived on it with permission by his stepfather. However, that argument cannot work because adverse in a common law adverse possession claim is the same element as it is as you have it adverse in a statutory adverse possession claim. And the whole point of a statutory adverse possession claim is that someone has purported to give land to someone. They've actually written out a deed, and they do try to transfer the land. They just do it wrong somehow. It's an unsuccessful deed. And so if trying to transfer land and just doing it unsuccessfully, if that counted as permissive so as to defeat any claim of adverse possession, then the whole scheme of statutory adverse possession wouldn't exist. And certainly here we're not asking for statutory adverse possession, we're asking for common law, but again, the element of adverse is the same in both. And there was this Supreme Court case that came out only 40 days ago, and it was after the briefs were filed, called Peggy Mathis versus 99 Hermitage LLC. And there the court, they use this new terminology. It's not terminology I've seen in any other court cases, but they say that you have adverse possession whenever there's a conflict of title. They had someone that did execute a deed, and the deed was actually correctly done. The only thing that someone was relying on there for adverse possession was the fact that they had never recorded the deed. And there the Supreme Court said that there wasn't any adverse possession because their possession was not adverse because there was no conflict of title. And specifically there was no conflict of title because the person that had been the recipient of the deed did have title, they just failed to ever record it. And so they said adverse possession doesn't apply in that scenario.
Well, in your case, there really wasn't any controversy regarding the right of possession because the other family members and stepfather allowed your client to reside there.
And I think that's basically right, but what the Supreme Court said in Mathis was they said, we conclude that our precedents are best read as requiring a conflict of title or a controversy regarding the right of possession. Mm-hmm. And so here, I don't know that we've got a very good argument about controversy about the right of possession, but we do have a good argument for conflict of title. And again, the Supreme Court just seems to have come out with that terminology within the last month or two, so that's why I wanted to bring it up. But certainly under that test, there is a conflict of title because my client was acting as though he had the title, but really he didn't. Really his stepfather had the title all along, and so that's a conflict of title that allows for adverse possession. And then the court held that he didn't exclusively reside on the property. However, the complaint does, I think, make relatively clear that he exclusively held about 5 out of 20 acres that were given to him, the stepson. The parents lived on another 5 out of 20, and then there were about 10 out of 20 that no one really lived on, but the parents just owned, and those were basically vacant, and those were going to be distributed to the other children. That was the plan. And so he exclusively resided on his part. he doesn't have to prove that he exclusively resided on the whole 20. Like if my next door neighbor fences off 10 yards of my front yard, and then I wait 15 to 20 years to do anything about it in court, I'm not gonna win that. He's gonna have adverse possession, and I can't say, well, you didn't fence off my whole yard. No, but he did fence off part of it, and, you know, part is all you gotta do to get adverse possession. So therefore, the dismissal of the adverse possession claim was incorrect. With regard to the dismissal of the other two claims, for express oral trust, the court held that we could not show any express oral trust because the statements were only oral. But the court, in making that ruling, was sort of missing the point, because the whole point of an express oral trust is that it can be oral. And under Tennessee Code 35-15-401, it says a trust may be created by, subsection 2, the declaration by the owner of property that the owner holds. The declaration by the owner that the owner holds property, identifiable property as trustee. And so the declaration, that's implying it can be oral, and then if you go down to 35-15-407, it specifically says that you can have an oral trust. It says, except as required by a statute other than this chapter, a trust need not be evidenced by a trust instrument, but the creation of an oral trust and its terms may be established only by clear and convincing evidence. So the point of an oral trust, as distinct from a better type of trust, a written trust, is just that an oral trust is harder to prove. And so if you want to do it right, you really should do it in writing, but you don't absolutely have to. So the court was wrong to dismiss the express oral trust on the basis that it was oral. As for the statute of frauds, which was raised by the defendant, seemingly that statute, that defense could only apply to the breach of contract and not to the oral trust, because the statute by its own terms specifically says it only applies to claims based on a contract or a lease, and that's in 29-2-101. But to whatever extent it could apply to the oral trust too, our same response could defeat it for both claims. It could defeat it both for the breach of contract and for the oral trust. And our response is that Mr. Scott engaged in extensive partial, or you could say complete, performance. So we're relying on partial performance and or equitable estoppel. And so if the only consideration that's demanded by the stepfather is that Mr. Scott clear the land and live on the land, I mean, he's cleared the land, he's built or set up his residence on the land, he's lived there for 30 years, he's paid taxes for 30 years. It's just hard to see how his performance could be any more complete than that. And so we would rely on partial performance and or equitable estoppel. And again, that would especially apply to the breach of contract claim, and then if necessary, it would also apply to express oral trust.
Let me ask you, with regard to the adverse possession, what was the conduct of the appellant that you say demonstrates that his possession of the 5 acres was adverse to others?
Well, I mean, we don't have a trial, we don't have a summary judgment record, all we got is the complaint, but the complaint just says that he openly held it out as his own, acted as though he were the owner. They both seem to agree that he was the owner, and he paid taxes on it for 30 years and lived on it for 30 years. And so those would be the main facts that we would rely on.
And that was included in the pleadings in your complaint, is that right?
Yes, Your Honor.
And you allege that constituted adverse possession?
Yes, Your Honor.
And this case was decided on a Rule 12 motion to dismiss?
Yes, Your Honor.
And so under Mathis, you're relying on the conflict of title component.
I was trying to take that latest case and see
look, I think you're right. I think we have to try to fit it under one of those two components. I just want to make sure what component you think is likely.
The conflict of title seemed to make more sense, and I was trying to figure out, does this Mathis case somehow hurt me because they didn't apply adverse possession there, and I would say it doesn't, because the main difference between here and Mathis is Mathis did have a real deed, they should have just recorded it.
Yeah.
Here, we didn't ever have a real
Well,
deed.
my follow-up question was gonna be, I'm trying to, what is the range of conflict of title? Is it enough just to say, oh, that's my property, which would seem to open up adversity to a lot of different things? Or do you have to have a piece of paper that says, oh, here's where I have claimed my interest, that's the conflict of title?
Well, I would say you don't have to have a piece of paper, because the courts have always, I've never seen any court disagree with this, always said that the adverse element is the same for statutory versus common law.
Well, yeah, but that's where you would go into the other component. It would be a controversy regarding the right to possession. And that's why I guess I'm challenging you a little bit on which Mathis component you're running under here.
I would say conflict of title
Okay.
should work, and even before Mathis, I mean, I just had never seen any case where someone had purported to give someone land, and that was called permission. Permission is talking about like if you're my tenant or something, and that's not what happened here. It was a failed transaction. So it was similar to statutory, except there was no actual writing. But unless there are any further questions, I will come back for rebuttal.
Thank you, Mr. Justice. Mr. Bobo, your argument?
Good afternoon, Your Honors. Andy Bobo from Bedford County Bar here for the appellee. Harold Burns is administrator of the estate of Donald Burns. As the appellant stated, they pled three separate claims for relief: adverse possession, express oral trust, and a breach of contract claim. I do want to first go back and factually, hopefully fill in some blanks, and I know we're dealing strictly with the complaint itself, but I do want to mention that per the complaint, ownership to the subject property was acquired at different times and in different ways. It wasn't all at once. The appellant correctly avers that Donald Patrick Burns, who's now deceased, as well as his wife, acquired the real property in one single tract, consisting of 20 acres in 1995. The complaint doesn't say that any outconveyances were made. It's a single parcel. It's taxed as a single parcel. There's no assertion of any formal divisions of individual tracts within the single 20-acre tract. The adverse possession claim, which is the first claim of relief, involves only a portion of the subject property, or as described by the appellant, single lot, which encompasses approximately a fourth of the land area of the subject property. And making a claim for adverse possession is just one of the appellants, which is Michael Scott. The last two claims for relief involve the remaining portion of the 20 acres, and presumably 3/4 of the subject property. First claim, wherein the appellant Michael Scott acquires title to a single lot by adverse possession, must fail. As the Chancery Court order states correctly, the plaintiffs cannot maintain their claim for adverse possession. Specifically in paragraphs 5 through 8 of their complaint, the appellants acknowledged that their possession was permissive. Donald Burns and his wife allowed the plaintiff's possession. The possession was not exclusive and it was not absolute. As the appellants, as it's undisputed, the appellants shared that possession with Mr. Burns and his wife, and Mr. Burns stated contingencies for the appellant's continued possession. The Mathis case was brought up today, and I agree with Your Honor. I think it's a slippery slope if, what degree of conflict of title is necessary. If I can simply walk in and claim I own this property, that's a very slippery slope. Yeah. And I think the distinction in the Mathis case is there was some basis. We had a deed. It was unrecorded. And I think that's a significant distinction between this case and the Mathis case. The second claim that the appellants and the appellee acquired title, or I should say the administrator of the estate acquired title to approximately 3/4 of the subject property by establishment of an oil trust, must also fail. We do recognize that there's a Supreme Court case that may be applicable to this scenario, and it's Sanderson v. Milligan, 585 Southwest 2D 573. And as Mr. Justice correctly stated, the premise of an oral trust is that it is oral in nature and not written, and we do acknowledge that. But we believe that the case in hand can be distinguished from the Sanderson case. In the Sanderson case, the Supreme Court found that a trust may rest upon a parole agreement where the declaration of the trust was made prior to or contemporaneous with the transfer, either by deed or will, or an interest in of an interest in realty. In the decision, the Supreme Court further states, of course, this is a safeguard against the trust, and terms must be proven by evidence that's clear, cogent, and convincing. Paragraph 4 and 5 of the complaint, the appellants assert that the trust was not established until after the transfer in question, or Donald Burns purchasing the subject property. As a result, the declaration of trust was not made prior to or contemporaneous with the relevant transfer, which we believe is necessary under the Supreme Court case that I just cited.
And we can tell that from the complaint?
I think so, Your Honor, and maybe I'm reading between the lines, but specifically what I base that opinion on is the paragraph 4, page 2, it says in 95, Donald Patrick Burns and his wife, mother of the plaintiffs, moved the property on Pickle Lane, encompassing roughly 20 acres. Specifically, the property was deeded as recorded in deed book such and such. The next paragraph says, upon said move, Donald Burns and wife promised. So there's at least a suggestion to me that it was done after
So the alleged oral trust created after move-in, which would make it cart before the horse, as it were.
Yes, Your Honor, and I think as the Sanderson case says, is that the declaration of trust has to be made prior to or contemporaneous with the transfer. We believe the transfer was first, trust came or the alleged trust came second. The final claim, a claim for relief or breach contract claim against the estate must finally fail. The facts surrounding this claim appear to be nothing more than a promise of some future conveyance. As the appellant alleges, there was some expectation of a future conveyance by either a will or a deed, which we do know a will or deed was never executed by the decedent, Mr. Burns. If the court does find that the elements for a contract have been met, we've argued statute of frauds, of course, as the court knows, require certain contracts to be in writing to be and signed by the parties to be enforceable. The appellant has raised the defense of equitable estoppel and part performance. Case law, we believe the appellate court in this state consistently refused to enforce an oral contract for the sale of land based on part performance alone. And it is now a rule of property in the state that part performance of a parole contract for the sale of land will not take an agreement out of the statute of frauds. Courts have further noticed that the harshness of this rule has been mitigated in the application of the equitable estoppel. But in two things in the case that I cited in my brief, in exceptional cases where to enforce the statute of frauds would make an instrument of hardship and oppression. And I think that's our argument here today as to why equitable estoppel would not apply. One, this is not an exceptional case, as well as the appellant does not allege in his complaint any hardship or oppression if the transfer is not upheld. For these reasons, we ask that the court here today uphold the trial court's decision to dismiss the plaintiff's complaint. Thank you.
Thank you.
Let me ask you, did
Sure.
the appellant build anything on that property that he alleges that he ultimately was going to receive?
Your Honor, there's nothing in the record. I think the only thing the record shows of any action on behalf of the plaintiff is that he did some clearing of the land.
Okay. Thank you.
Yes, sir.
All right. Thank you, Mr. Bobo. Mr. Justice, your rebuttal.
Your Honors, what the complaint says is that in response to these promises, Scott not only helped clear the land, but also occupied and lived on his allotted area, openly claiming it as his own and even paying taxes thereon for almost 30 years. And so that's what it's referencing in terms of him setting up his
Now,
residence.
how did he pay taxes if the property wasn't divided?
The record I was trying to look through the record to see if Mr. Bobo was correct. I don't think the record states anything about whether it was or wasn't divided. There's no deeds or anything in the record, so I don't know where he's even
Well-
getting that from the record. But whether it was or wasn't, I'm not exactly sure how he did. He may have had to, like, you know, give the money to the actual title holders to bring to the clerk or whatnot. I'm not sure.
Well, and I'm also guessing we're just gonna have to assume that fact is true since it was pled. I mean,
Yes, Your Honor, that's our
maybe
position.
he overpaid and paid the entire, for the entire 20 acres.
Correct. And in terms of, you know, whether there's any hardship, I mean, if he's clearing all these acres, he's setting up his home there for decades, he's paying taxes on it for decades, I would just consider that a hardship that he's suffered if he's done all that for nothing.
What do you mean by setting up his home?
I'm sorry.
Something constructed on that?
I don't think the record said, I think it's a trailer rather than like an actual built home, but again, the record doesn't clearly say one way or the other, so I'm not positive. In terms of the, and I wanted to just address this Sanderson versus Milligan case. I'm not sure that opposing counsel is even reading that case correctly, because it seems to me that the conveyance could be the conveyance not to the trust, not to the person who then creates the trust, but it could be the conveyance to the trust. But regardless, I would just submit that these statutes I'm citing on oral trusts were enacted like almost 40 years after that case. That Tennessee Code 3515-401 and 407 were both enacted in 2004. And so if those need to modify the results of that prior case from decades earlier, certainly they could and they would. And for all those reasons, I would just ask that Your Honors apply the rule of TrawMed of America Incorporated versus Allstate Incorporated and liberally construe the complaint and adopt all reasonable inferences in favor of the non-moving party. And under that standard, I just submit that we should prevail and the case should be reversed and reinstated.
Thank you, Mr. Justice and Mr. Bobo, for your arguments. We'll take the matter under advisement. That concludes the docket.